My name is Alan Robertson. I'm the President of the Australian Academy of Law. I acknowledge the Gadigal people of the Eora Nation on whose lands we are meeting this evening and acknowledge their elders, past, present and emerging. This is, I think, the first occasion on which the AAL and the ALRC have come together to conduct a seminar. The idea was put to the Australian Academy of Law by Justice Sarah Derrington in December, and I accepted the idea straight away. I hope there will be more such seminars on this or other references given to the ALRC. I thank the Chief Justice of the Federal Court of Australia, Chief Justice Alsop, for making this courtroom available for this evening's event. My task is to introduce Justice Sarah Derrington, who's chairing the seminar. Justice Derrington is a graduate of the University of Queensland with a BA and an LLB with honours. In 1990, she was admitted to the bar in Queensland and as a barrister and solicitor of the Supreme Court of the ACT, where she began practice in the litigation section of Freehills. Subsequently, she spent a year in the insurance litigation section of Minter Ellison in Brisbane, and then commenced part-time practice at the private bar while pursuing an academic career at the University of Queensland. Her Honour graduated in 1996 with an LLM and in 1999 with a PhD in the field of marine insurance law. Justice Derrington was appointed Professor of Admiralty Law in 2008. At the time of her appointment as a judge of the Federal Court and as a President of the Australian Law Reform Commission in January 2018, Justice Derrington was the Dean of Law at the University of Queensland and a barrister specialising in maritime and shipping law, general commercial law and arbitration. She has published many learned articles and with James Turner QC of the English Bar has authored The Law and Practice of Admiralty Matters, now in its second edition. She was elected a Fellow of the Australian Academy of Law in 2009. By terms of reference dated 11 September 2020, the Attorney General asked the Australian Law Reform Commission to undertake a review of the laws relating to impartiality and bias as they apply to the federal judiciary. And that's what brings us here together this evening. I now hand you over to Justice Derrington.
First of all, I would like to thank the Academy of Law and in particular the Honourable Alan Robertson for partnering with the ALRC for this seminar. I acknowledge all the distinguished guests participating in the seminar in person and via Teams, and let's hope that the technical glitch has been fixed. In particular, though, I wish to acknowledge the Honourable Minister Amanda Stoker, the Assistant Attorney General, who has joined us online, the Honourable Robert Nicholson AO and the Honourable Kevin Lindgren, both former presidents of the Academy of Law, Sir Ross Cranston QC joining us from the United Kingdom, and Emeritus Professor Ros Croucher AM, former President of the Law Reform Commission. In September of 2020, the ALRC received terms of reference asking it to consider whether, and if so, what reforms to the laws relating to impartiality and bias as they apply to the federal judiciary are necessary or desirable. The following matters were specifically drawn to our attention. First, whether the law about actual or apprehended bias remains appropriate and sufficient to maintain public confidence in the administration of justice. Secondly, whether the law provides sufficient clarity to decision makers, the profession and the community about how to manage potential conflicts and perceptions of partiality. And thirdly, whether current mechanisms for raising allegations of actual or apprehended bias and deciding those allegations are sufficient and appropriate. We were also asked to consider any other matter related to those terms of reference. And with that liberty, the ALRC has embarked on a broader consideration of perceptions of systemic bias within the federal judicial system, such as unconscious bias, judicial conduct in the courtroom that leads to perceptions of bias, and considerations of other measures that might enhance public confidence, including the appointments process, judicial education, and complaints mechanisms. This evening's seminar is part of the ALRC's broad consultation process, where we seek to elucidate the issues and gather concerns and suggestions from a wide variety of interested parties. Following this initial round of national consultations, we will release a consultation paper at the end of April and then call for formal written submissions. We are expected to report to the Attorney-General by the end of September, but many of you will be aware that the week before last, the High Court gave special leave in the case that we understand prompted this inquiry, Charistius and Charistius, and we would not want to prejudge the decision of that court. So tonight we have asked a distinguished panel to assist with the current consultation process by speaking to you about their perceptions on aspects of the inquiry. Once the panellists have spoken, you are then invited via the email impartiality@alrc.gov.au to submit questions that I can then direct to panel members. That address again is impartiality@alrc.gov.au. So let me now introduce our panel. First, joining us from far mid North Queensland is Mr. Anthony McAvoy SC, who is a member of our advisory committee for this inquiry. He's chair of the Law Council of Australia's Indigenous Legal Issues Committee, Wangan and Jagalingou traditional owner, and is Australia's first Indigenous silk. He was admitted as a solicitor in Queensland in 1988 before he went on to focus in the area of native title and land rights. He came to the New South Wales Bar in 2000 and took silk in 2015. He has a strong native title practice and also practices in areas of environmental, administrative law, human rights and discrimination law, coronial inquests and criminal law, and has served as an acting part-time commissioner of the New South Wales Land and Environment Court. Tony will start the discussion this evening by interrogating the fair-minded lay observer, or as one participant in our consultations recently described it, the fair-minded Chief Justice on the Clapham Omnibus, or perhaps the Manly Ferry. So, Tony, I'll ask you to start proceedings.
Thank you, Justice Darrington. And I want to express my thanks to the Australian Law Reform Commission and the Academy of Law for hosting this event. I also acknowledge that the event is being held live on the lands of the Gadigal people. I acknowledge their neighbours, the Dharawal, the Gunungurra, the Darug, the Tamaragal, the Guymaragal, and I also acknowledge the Barada and Kapalbara people on whose country I am on presently in central Queensland. I've been asked to speak to you briefly about our fictional friend, the fair-minded observer. It goes without saying that, amongst other matters, the level of public confidence in any justice system will be determined by the perceived impartiality of that system. In our federal judiciary, we are not considering the role of juries, only our judicial officers. Nor am I in this short address talking about actual bias. In Australia, the determination of whether a judicial officer should remove himself or herself from any proceedings or be removed on the basis of an apprehension of bias is guided by the case law. The test is whether, in all the circumstances, a fair-minded lay observer with knowledge of the objective facts might entertain a reasonable apprehension that the judge might not bring an impartial or unprejudiced mind to the resolution of the question. This is determined in two parts. First, it's necessary to identify the fact or circumstance that might lead the decision maker to be less than impartial. Some of the circumstances that have been identified that might give rise to such an apprehension are where the decision maker has an interest in the proceedings, or by the decision maker's conduct, or by the decision maker having access to or possession of extraneous information, or their association with parties or the subject matter. This is not a closed list. Once satisfied that the interest in or connection with the proceedings exists, a logical connection between that interest in or connection with the proceedings and the complained effect on the decision maker's impartiality must be shown. In Johnson & Johnson, a 2000 High Court of Australia decision, Justice Kirby described the fair-minded observer as follows. Such a person is not a lawyer, yet neither is he or she a person wholly uninformed or uninstructed about the law in general or the issue to be decided. Being reasonable and fair-minded, the bystander, before making a decision important to the parties and the community, would ordinarily have be taken to have sought to be informed on at least the most basic considerations relevant to arriving at a conclusion founded on a fair understanding of all the relevant circumstances. Now, there have been many conceptions of that fair-minded observer over the years, but if we accept that the description that I've outlined above is reasonably accurate, it is clear that the actual fair-minded observer might have difficulty determining what it is they are supposed to know in order to make the decision. The reality is that in most cases, the lines will be blurry because the very flexibility that's needed to be built into the system to achieve as fair a result as possible. However, if the process of decision making as opposed to the result is opaque, and is so opaque as to not inspire the public with confidence as to the decision making process, then there is an impact on the delivery of justice. The question could then be asked, what can be done to make the process more accessible to the public? Some have argued for codification or partial codification, and while it is possible that there might be some very limited codification of the area in terms of particular relationships between judicial officers and the parties or the matter, it seems to me that it is difficult to proceed very far down that path without losing the flexibility necessary to accommodate the variety of circumstances that will and do arise. I note that our colleague Dr. Gabriel Appleby is speaking on the self-disqualification process later and some models for reform, and I think that that discussion has a lot of merit, particularly in inspiring greater confidence, public confidence, where we still need a system that has significant flexibility. I look forward to questions later in the seminar, and I will leave you with that teaser to start. Thank you.
Thanks very much, Tony. Our second panellist is the Honourable Justice Michael Lee, Judge of the Federal Court and an additional Judge of the Supreme Court of the Australian Capital Territory. He recently found himself unpacking suggested tensions between efficiency in modern case management and the bias rule as the subject of an application for disqualification on the grounds of apprehended bias arising from hearing related proceedings together. It's Webb and Get Swift number 6. He had already foreshadowed this possibility in an earlier judgment, but considered that a reasonable apprehension of bias did not arise. The interlocutory order dealing with apprehended bias is currently on appeal, giving us the perfect example for our report of how such appeals can be handled procedurally. Beyond the considerations of the law, the application has given Justice Lee the opportunity to impress upon us the importance of referring in our report to applications for disqualification rather than the American recusal. His Honour said, Get Swift and Mr McDonald contend that I should recuse myself from the initial hearing of this class action. For reasons which are unclear, over the last decade or so, the Americanism recuse seems to have been almost uniformly embraced to describe applications of this type. But perhaps, futilely, I will continue to describe the present application as one whereby I am asked to disqualify myself. Please welcome Justice Lee.
Thank you, Justice Derrington. Now, it's fair to say that the impact of applications for disqualification on judges and courts could be described as a somewhat large topic, and certainly with its considerable understatement, I say that I can't do justice to it in 5 minutes. So what I've decided to do is very quickly raise a couple of issues relevant to the topic that arise out of 3 cases, which I've decided, one in 2019, one in 2020, and one 3.5 hours ago. In relation to the first decision, which is McKenzie and cash converters, focusing on the notion of the impact of applications for disqualifications on judges, I'd commend those practitioners to have regard to the procedure by which such an application should be brought under the current applicable regime. That is set out at paragraph 6, and the importance, if counsel are involved or legal representatives are involved, to initially raise the potential of an application with the judge in advance of it being made. And Justice Rothman in a case which is referred to there explains why that aids the administration of justice, including giving the opportunity of the judge to disqualify him or herself without the need for a hearing. This is a case where I was asked to disqualify myself because I had previously advised and appeared in another proceeding against the respondent in the proceedings. Now, it raises a particular issue that Tony touched upon, and that is this fiction that we all have to cope with. And I describe that as a fiction used to connote a degree of detachment or objectivity to a process which inevitably involves the application of normative standards of behaviour determined by the court itself. That is, we've developed this hypothetical referee, this hypothetical observer, but really what we're dealing with is a determination by the court of the application of normative standards of when disqualification is appropriate. I had completely and utterly forgotten about this other proceeding some years before, and I, for other reasons, dispatched it by saying, before leaving the hypothetical observer's attributed knowledge, I should make a further point. Although senior counsel for cash converters accepted, correctly as it happens, that as a tolerably busy barrister who acted in a large number of matters, it would not be expected I have present recollection of being provided with material or providing advice in relation to the proposed proceedings. It's somewhat difficult to make too much of this point. Although well informed, the ordinary hypothetical observer may find it difficult to appreciate how the prosaic details of briefs quickly depart and recede into the Cimmerian darkness of lost professional memory. As senior counsel for cash converters submitted, it is reasonable to assume a hypothetical observer may consider that provision of material on the substantive application might possibly prompt some form of memory. On balance, I think it's fair to proceed on this basis. I will put to one side as being irrelevant my certitude that at this remove, my ignorance of the details of the previous proceeding is so profound as to make any triggering of cogitations on a long forgotten and relatively insignificant brief as unlikely as they would be unwelcome. The point I was trying to make there is that there is a need to temper these applications with some degree of reality, particularly when it comes to the notion of extraneous information. And a lot of applications are made on a relatively infirm basis, and it's to the credit, it seems to me, the reference is made particularly worthwhile by the degree, I think, of ambiguity about when these applications are appropriate, apart from the other difficulties one sees in the case law. The next case that I'll mention briefly is the one to which Justice Derrington made brief reference, because this really is the way a problem the courts have to cope with. In particular, in this court, there is an increasing phenomenon of regulatory proceedings and large commercial cases, including often class actions, dealing with the same substratum of facts. Those cases are often huge, which involve a mastery of a massive amount of adjectival information. If we're serious about the appropriate allocation of both private and public resources, the notion that there should be two quite separate hearings heard by two judges with all the consequent waste of public resources that involves, including the disruption of the court list, which has a knock-on effect in relation to other litigants in the court. There's a real tension that emerges between being too ready to disqualify oneself on the basis of extraneous information and thinking, is there a way in which these tensions can be reconciled? One of the things I referred to in this case is one of these tensions, hopefully the ALRC will look at this, in the authorities, between the notion which one sees in a number of cases about where there is any real possibility that the trial judge's participation might lead to a reasonable apprehended of prejudgment or bias, the trial judge should, of course, refrain from sitting, with the notion one sees in another large number of cases, and that is that it's important that disqualification should not occur unless substantial grounds are established. So one sees this tension. Part of that is the notion that, particularly in large cases, if a judge decides not to disqualify himself or herself, here's a case, goes on appeal, and a full court takes a different view, then there's potentially a very large waste of public resources. Cognizant of this in Webb and Getswit, what I did was determine the application and then grant leave to appeal against my own decision before the matter went on further, so the issue could be resolved at least at intermediate court of appeal level prior to proceeding. But that is a real issue of the impact of the purity of and the necessity for people to have controversies quelled by a court free from bias, apprehended bias, a properly constituted tribunal with the notion of, well, where does that go in terms of its impact on the court? The third is an example again between tension of in the efficient disposition of proceedings and principles of apprehended bias. I delivered judgment this afternoon in relation to a case in which it was alleged that a senator of the Commonwealth had, Mr. Burston, had sexually discriminated against an applicant, and she had sued both the senator and also the Commonwealth the former senator and the Commonwealth on the basis of the Commonwealth being vicariously liable for the senator's actions. There was a deed by which it was contended that the resolution of the claim against the Commonwealth occurred, was resolved, and what I determined to do was to identify and separate out and determine separately before any issue whether or not the applicant was able, by reason of the application of equitable principles, Grant and John Grant, to successfully argue that the Commonwealth, it would be unconscientious of the Commonwealth to rely on the general words of release. That involved an inquiry into the subjective actions, both the knowledge and other actions of both the parties when it came into signing the deed, and I had to hear evidence about it. I made some credit findings and determined that the Commonwealth had acted appropriately and no relief should be granted, which prevents the deed being enforced according to its terms. Now that caused a problem immediately because I made a credit finding against the applicant, who then had a claim in my docket against the remaining respondent in the proceedings. So without the need for any application, I formed the view that, and said this at paragraph 48, during the course of the hearing I formed views as to the applicant's reliability as a witness and her manner of giving evidence, and expressed those views. In those circumstances, although I didn't consider the applicant set out to give any false evidence, there are aspects of her evidence I do not accept, and a hypothetical observer might reasonably apprehend that if I hear evidence from her again, which would inevitably be the case, I might not be able to bring an impartial mind, therefore I disqualified myself and had the matter referred to the National Operations Registrar for reallocation. So you can see in all these cases there's a tension. I have no doubt, subjectively, I think I could compartmentalise those things. But what I think I can do is very different from the objective analysis of the hypothetical referee. But that there is an impact every time a judge disqualifies him or herself. There's an impact on the court, and some clarity in relation to this area, which has some ambiguity, is going to be very welcome. Thank you.
Justice Lee. Our third panellist, who has come up from Hobart especially, is Professor Gabriel Appleby, who is also a member of our advisory committee. She is Director of the Judiciary Project at the Gilbert and Tobit Centre of Public Law at UNSW and has published extensively on issues particularly relevant to this inquiry, including the procedures for disqualification of judges on the ground of bias, ethical support structures for judges, structures to respond to judicial misconduct, and the dangers of casual empiricism in relation to analysis of judgments using statistics. Professor Appleby is a graduate of the University of Queensland and is very familiar with a high-profile case of judicial disqualification in that state, having co-authored the book The Tim Carmody Affair, Australia's Greatest Judicial Crisis. Please make her welcome.
I too would like to start by thanking the Australian Law Reform Commission and the Australian Academy of Law for the invitation to speak tonight. I'm really honoured to be speaking in such esteemed company and on a topic that I think is foundational for the public's confidence in our legal system. Before I commence my remarks, I want to acknowledge that what I'm speaking to today draws from two articles that I've written with my colleague and friend, Stephen McDonald SC of the South Australian Bar, and I thank him for his provocations and insights in those pieces. So I'm critiquing tonight the self-disqualification procedure that applies where there is a claim of apprehended bias. The then Chief Justice of the High Court of Australia, Robert French, said in 2011 that the interposition of the fair-minded lay observer has utility as a construct in that, and I quote, "It reminds the judges making such decisions of the need to view the circumstances of claimed apparent bias as best they can through the eyes of non-judicial observers." In my brief comments, I want to use the results of behavioural psychological studies to interrogate this idea that judges can view the circumstances of claimed apparent bias through the eyes of any third party, whether that be a non-judicial or judicial observer. Now, I'm not an expert in behavioural psychology, but I have drawn on the work of others to try to understand what some of these studies mean for the self-disqualification procedure as it relates to apprehended bias. So whether judges as humans can assess their own situation from the perspective of a fair-minded lay observer has been the subject of some research in the US, which has looked at the effect of bias blind spot in these circumstances. And I draw in my articles on research that was done at Stanford and Cornell universities in the 2000s and that has been applied in that US context to the judicial self-recusal procedure. So what is bias blind spot? The bias blind spot describes the cognitive illusion whereby individuals tend to fail to see bias in themselves, but they readily infer bias in others. That is, individuals are confident their own decisions will not be corrupted by bias, but do not have the same confidence in the decisions of others. Indeed, this research shows that they are likely to exaggerate bias in others. Research shows that even when people know of the existence of the bias blind spot, they're unable to adjust their assessments. So, for instance, one of the studies that we draw upon concludes, and I quote, "A personal connection to a controversial issue," in this case it was in relation to conflicts in the Middle East, "will be seen as less biasing and more enlightening when it applies to oneself or someone on one side than when it applies on the other side." So what does this mean for the apprehended bias test? It means that judges applying the reasonable apprehension of bias test to themselves are doing so battling against two cognitive bias blind spots. One that relates to assessing their own circumstances and whether they amount to apprehended bias, and the other that relates to the perspective of others in assessing their circumstances. So what to do? The obvious response to the concerns that I've raised is to have an alternative judicial decision-making determine a question of apprehended bias. Now, it could be argued that this might create in-house tension between judges, or that it might create the impression that there is now a matter that's evolved between one of the parties and the judge. Now, these concerns, I believe, are somewhat overstated. As to in-house tension, judges, of course, sit on appeals from their colleagues, including on questions of apprehended bias. Further, any application against a judge already brings with it a perception that a judge has become, if not a party to the application, they have become at least more personally involved in the proceedings. And this would occur also should the matter be subject to review or appeal. The bigger concern, I think, is that about practicality and efficiency. A strict rule precluding a judge from determining questions of apprehended bias in all cases could prove unworkable, particularly in some of our already overloaded trial courts. There is, therefore, the need for more creative responses, perhaps. In our work, Stephen MacDonald and I have considered two possible options. The first would be a system where a second judge or panel would be brought in upon the request of the challenged judge, where that judge is satisfied that a minimum threshold has been reached. The second would be a system whereby the challenged judge makes the decision, but there is an expedited review process available against that decision. An even bigger concern about the self-disqualification procedure is one that was raised today in an academic roundtable that I was involved in that was hosted by the Commission. While the solutions that I've proposed might address the problem of the cognitive biases of the individual judge, it doesn't address perhaps a public apprehension that judges may be looking after themselves even in this modified procedure. Now, how that public perception can be addressed is a much bigger question that extends far beyond my research that's looked at the individual cognitive biases of individual judgments. It raises questions perhaps about the role of laypersons in such a procedure. It raises questions around judicial composition and diversity of the bench. It raises questions around what structural mechanisms might be there and transparently there to assist judges when they're making these decisions. So one final comment before I finish, and this relates to the ethical obligation of the judicial officer to disclose facts and circumstances that might give rise to bias and apprehended bias that exists under the current test. Now, there are two potential problems that I can see in this current process. The first is the reliance on the judge through an imperfect, and by that I mean an unenforceable ethical obligation to disclose facts, and whether members of the public might be satisfied that this is sufficient to ensure that all facts are always disclosed. The second relates to those circumstances, albeit rare, where there might be a dispute around those facts. For instance, there might be a conflicting version of a judge's conduct at an event that relates to the case. If a judge accepts his or her own version of the facts, a party may legitimately feel aggrieved that they have not been given an opportunity to test that version. Now, Justice McHugh in Vacotta and Kelly, a 1988 decision of the New South Wales Court of Appeal, said, and I quote, "If a dispute exists between the parties or the judge as to what was said, the version of the judge must be conclusive." End quote. Justice McHugh referred to the unthinkable situation of a judge giving evidence or being cross-examined, and appeals to the finality of judicial decisions as to questions of facts. Now, whether he is right as a matter of principle, it is hard to see that a lay observer could possibly accept this as a fair outcome. So what alternative procedure might exist? In these circumstances, bringing in a second judicial officer or a panel would alleviate the perception of a judge being a judge in their own cause, as to their own credibility. To avoid the potential of a judge giving evidence, though, we've suggested that there must be additional procedures adopted or principles adopted to limit that as far as possible. And this is alternative principles to limit as far as possible then the need to make decisions as to a final decision as to questions of facts. So this includes that an assessment of apprehended bias must take into account the fact that the facts are in dispute. So the test of apprehended bias must take into account the fact that the facts are in dispute between at least one party and the judge. And this, I should note, is what occurred in the 2012 New South Wales Court of Appeal decision, the facts of which I referred to earlier in CUR 24 and the DPP of New South Wales. I'll conclude with that and look forward to the discussion. Thank you.
Thank you, Gabriel. Our next speaker is His Honour Judge Matthew Myers, AM. Judge Myers became the first Indigenous Australian to be appointed to the Federal Circuit Court in 2012. In 2017, he was appointed as Commissioner to the Australian Law Reform Commission inquiry into incarceration rates of Aboriginal and Torres Strait Islander peoples, which considered systemic and structural biases against First Nations people in the justice system. As a judge dealing with family law matters in a busy court, he is well attuned to the dynamics of maintaining perceptions of impartiality in highly charged proceedings in a system subject to significant pressures in terms of time to deal with matters and a large proportion of self-represented litigants. I invite Judge Myers to address us.
Thank you. I'd like to acknowledge the traditional owners of the land on which we meet and talk tonight, the Gadigal people of the Eora Nation. I pay my respects to their elders past and present and to any other Aboriginal and Torres Strait Islander people here tonight or on the video link. I'll get you to do something for me if I can. Can you visualise something for me? Try and think about what I say. If you need to shut your eyes and visualise it, shut your eyes. But genuinely do it if you can. Visualise this. You're a speaker at the next fantastic AAL ALRC conference. It's going to be held in Melbourne. It's a really great topic. You're one of the speakers. You're really, really keen to go there and you are racing to get to the airport to jump on a plane to Melbourne and you're running late. You race into the terminal, you've already checked in and you hear your name being called, you leg it to the gate, you make it to the gate, you race down the flight deck, and as you race down the flight deck, jump straight on the plane, and just as you get on the plane, there's the captain standing there looking at you. Hello, the captain says. You go and you take your seat. Anyway, you make it down to Melbourne, you get off your flight, take your taxi, go to your hotel, you check in and you get upgraded. Great, I got upgraded. Anyway, go to your hotel room, you walk into your hotel room. This is absolutely amazing. Fantastic room. I hear a noise in the bathroom. Something's banging. I feel a bit concerned. You go into the bathroom and you see in the bathroom the housekeeper, desperately trying to get the room ready, hugely apologetic, hugely courteous. The housekeeper finishes and off the housekeeper goes. Anyway, you've organised to meet some friends. You haven't seen them because they've been locked down in Melbourne forever. You go down to the restaurant, you sit down at the restaurant, you're at the table waiting for your friends to arrive, have a meal, and you're on your own. You hear or you see an attractive couple sitting next to you where you're sitting, and you overhear it's their wedding anniversary. Anyway, they're celebrating. Your friends arrive, you have your dinner, great to catch up with your friends. Go back to your hotel room, hugely restful sleep, wake up refreshed in the morning, able to go to the conference and do your talk. Anyway, I want you to think about three people in your story. The first, your pilot, the second, your housekeeper, and the third, the celebrating couple with their anniversary. You can visualise them. I want you to visualise them just for a moment, and I want you to ask yourself this. Was the pilot black?
I got it black, mate.
Okay.
But I don't think anybody would have imagined them like themselves.
Was the housekeeper male? Was the couple same sex? Joe gets full marks. Anyway, look, I'm here to talk to you about the exciting topic of the night, unconscious bias. We all make unconscious decisions every single day. If you don't believe me, I challenge you to it. Our life depends on it. Every time we drive in the car, every time we cross a busy street, we are making an unconscious decision. I want you to think about some of the biases you got. When I see an L plater or a P plater and I'm about to cross the road, what do I think? We are pre-programmed. There is built within us an instinct that's kept our people alive for 200,000 years. Our flight or fight reflex. It's still with us. If you've ever, our ability to discern danger, to ascertain friend or foe, to work out, is this a member of an opposing aggressive tribe, instantly has kept us going to this point. If you've ever met somebody and your hair stood up on the back of your neck, you've ever said that person gave me the creeps, they gave me the heebie-jeebies, you just made a decision based upon unconscious bias. Research shows us there are numerous unconscious bias. Affinity bias, known as similarity bias, where we feel comfortable with members of our tribe or our group. There are many old sayings that recognise this. Like with like, birds of a feather, they recognise affinity bias. Attribution bias, where we incorrectly evaluate the reasons for somebody's success as being luck rather than effort or skill. Attractiveness bias, often called beauty bias, where we view attractive people as more competent, but we view less attractive, and here's the interesting part, or very attractive people as less competent. There are, of course, other forms of unconscious bias, including gender bias, name bias along ethnic or cultural lines, age bias and racial bias. An Australian study by Goodman, Delhunty and Spores, titled Unconscious Influences in Sentencing Decisions, a research review of psychological sources of disparity, identified sources of bias including features associated with the judge or features associated with the defendant. By and large, research on unconscious bias centres on employment and its effect on diversity in the workplace. Tonight, I challenge you to think about unconscious bias and think about the diversity on the benches of the courts of this country. Thank you.
Thank you very much. Our final speaker this evening is Mr. Chris Merritt, Vice President of the Rule of Law Institute of Australia, who writes a weekly column on legal matters for The Australian. He's former Chief of Staff of the Australian Financial Review and was founding editor in 1997 of the paper's Legal Affairs section. He holds an honours degree in law from UTS and is admitted to the bar of the New South Wales Supreme Court. He has reported on the stories where judicial bias has risen to the level of controversy, including the Tim Carmody affair and the Dyson Heydon Royal Commission. Given the role that the media has in shaping public confidence in the judiciary, I invite Mr. Merritt to address us.
Good evening. I want to talk about one case that raises a number of points. It concerns the late Guy Andrew, a judge of the Federal Circuit Court, who had been the only judge of that court in Townsville. His story suggests that in some cases, the appearance of bias might be linked to judicial welfare, or lack thereof. The lesson for the future is that a greater focus on welfare might have broader benefits. Judge Andrew joined the bench in March 2019 and was found dead in bushland outside Brisbane in October last year, after he was moved from Townsville to undergo counselling. He was moved after his conduct during a family law case known as Addicott and Sowell was criticised by an appeal bench of the family court. The appeal court overturned his original decision and ordered a retrial because of what can accurately be described as an extraordinary case of apprehended bias. But in the light of what happened to the judge, his conduct can be characterised in a different way. It was also a strikingly clear sign that something was seriously wrong with the judge, something that was far more fundamental than bias. The unanimous judgment of the appeal bench of the family court contains extracts of the transcript of the original decision, that cover 17 pages. They show that the judge was engaged in extended verbal jousting with lawyers for one of the parties, that the appeal bench described as, and I quote, cruel, insulting, humiliating and rude. I'm not going to cite the exact words. I don't think it's necessary. Judge Andrews' body was found last October. In September, the month before, the reasons published by the appeal bench of the family court had been reported widely in the media. I have no criticism of the appeal court or of the media. I think it would be a mistake to criticise sensational coverage of an event in a court based on a public document that is itself sensational. The court, the appeal bench, and the media were simply doing their jobs. My criticism is reserved for what I think is an institutional gap, the absence of a federal judicial commission that could potentially have led to a different outcome. There might have been another way of addressing not just bias, but the welfare of the judge. My friend Nicola Berkovic reported in The Australian that Judge Andrew had been the subject of 2 complaints. If a federal judicial commission had been in place at that time, consider what might have happened. Judge Andrew had been on the bench only since March 2019. A federal judicial commission, if modelled on the New South Wales Commission, would have functions that include mentoring and judicial education. Judges, of course, do what they can to help each other, but they are judges first and mentors second. An important institution needs to have institutional support for the welfare of its key figures, particularly those who are isolated from their fellow judges. Hopefully, the federal government's design for its promised Federal Judicial Commission will include such a function. The second point's this: a Federal Judicial Commission might have been able to deal with concerns about the judge's conduct before they reached the point where there was a need for an appeal and a retrial, the cost of which, by the way, is all footed by taxpayers. I'm aware of 2 instances where judicial officers in New South Wales have resigned and left the bench quickly after simply being informed that aspects of their conduct were about to be examined by a conduct division of the Judicial Commission. An adverse report by a conduct division is the first step in the process of removing a judge from the bench. That mechanism, which protects litigants, is only possible because conduct divisions are required to abandon their inquiries once a judicial officer leaves the bench. The downside of this approach, and it is a downside, is that it deprives complainants of the satisfaction of seeing their complaint upheld. So from an individual complainant's point of view, it must be terribly unsatisfactory. But what strikes me as more important is the need to protect all future litigants from judicial officers whose conduct or capabilities are no longer of the required standard, and to do so promptly, which is how the New South Wales system has worked. The third point's this: the appeal bench of the family court clearly reached the correct decision when it ordered a new trial. But it was only able to do so, in my view, after reading down the rule that means litigants waive their right to complain about bias if they fail to raise this issue when it becomes apparent during the trial or before the trial. There was no application during the trial for the judge to recuse himself, or I'm terribly sorry, to disqualify himself from the bench. The appeal court, however, unanimously pointed to the fact that one of the lawyers who had been bullied reminded the judge that he had described the lawyer as a disgrace. That looks to be strained, but a necessary technique that had to be adopted if this clear case of bias was to have been heard, and if the decision by the appeal court was to go ahead. Why not simply abandon that rule, that waiving your right to complain about bias? In their book, The Australian Judiciary, Enid Campbell and H.P. Lee make the point that the rule against bias is a fundamental pillar of natural justice. If that rule can be waived by parties to litigation, one of the basic features of the judicial process is being compromised at the instance of one of the parties to a case. That can't be right. I'll leave it there.
Thank you very much, Chris. We now get to that part of the seminar where you are encouraged, please, to ask questions. Does anybody who's here in the courtroom wish to ask a question? Would you mind just telling us who you are?
Oh, my name is Kylie Nomchong of the Sydney Bar. I have a question for Justice Lee. In the decision that you handed down today, Your Honour, you made a determination where you said that you found found one of the applicant unreliable in her evidence. Don't you think that that then creates an inherent bias, because the judge to whom it's passed will necessarily read the judgment that you've made, and then that very statement then might infect him or her in the way in which they view the applicant?
Well, there is always a risk in the real world that comments like that will impact upon any decision maker coming to assess somebody's credibility in a different context. I accept that that's an inevitable consequence of adverse credit findings. The reality is, in order to determine the issue, one had to inquire into and make findings on conflicting evidence. And of course, ever since Fox and Percy perhaps highlighted the issue, which is 2002, 2003, and the caution that judges should take in thinking that they are have a special equipped training to make demeanour-based credibility findings. There is a huge raft of literature which encourages judges to think about the inherent probabilities and to draw in, and pays primary reliance on contemporaneous facts and what emerges from the documentary material. But sometimes, in an I said, he said situation, it is necessary to make such findings, and regrettably, that can lead to, or perhaps not regrettably is the wrong word, but that can lead to adverse credit findings. So the point you make is perhaps harkening back to notions of unconscious bias. I mean, all one hopes, and the hypothetical fair-minded observer, we can't fail to recognise the importance of the judicial oath, that people must make decisions on the basis of the evidence before the judicial officer. The system can't work without people feeling that judges should be equipped by their training and experience to be able to put to one side the irrelevant and decide cases on the basis that are relevant. There are obvious real-world limitations in respect of that, but unless that fundamental aspect of the judicial process is given prominence, then really the system breaks down.
Justice Stewart.
The point that Kylie Nomchong makes illustrates again the tension that Justice Lee was raising earlier, sometimes in considerations about how to deal with fundamental questions such as bias, and on the other hand, case management imperatives, because usually one would avoid that situation by not separating out an issue in a case where the same person may have to give evidence twice and credibility issues might arise. But sometimes that can't be avoided or isn't avoided, and then within the same case, one has exactly that situation that arose in the Leach case that was delivered today.
Is there anybody else? I wanted to ask Judge Myers, perhaps in hindsight, can you think of a time on the bench when you noticed or became aware of unconscious bias by your decision-making process?
I'll stand up.
You can stand up or you can speak from the microphone.
It's okay. It's a difficult question, but in the work that we do, or the work that my court does, we deal with very ordinary problems with ordinary everyday people fighting over their house, their property, and fighting over their kids. A very large percentage of the people that come to our court are self-represented, and I remember on one occasion having a couple in their mid-30s, both attractive, not super attractive, just attractive, well-dressed, groomed. Both of them self-represented, both of them filing terribly scant applications. Dad coming to the court asking to spend time with his very young child of about 12 months of age. Mum desperately unhappy, not able to discern at all how it was these people were together and any history of their relationship. There's a case called Re Litigants in Person Guidelines, and it requires judges of my court and the family court to try and unpack, try and work out what are the applications of the parties, what's going on. And I started to talk to the couple, and I said, I can't understand your relationship. And they said, well, there wasn't a relationship. We met each other on Tinder. We met each other on Tinder. We had a relationship of less than a week. And as a result of that, they fell into each other's beds very, very quickly. They had a child, but they were desperately unhappy. And I said to them, look, I understand you're unhappy. You've not communicated. You've not had a relationship. You've had no communication. Maybe you need to sit down and start talking about your communication, talking about meet with each other. Go and have a cup of coffee once a week. Go to somewhere, you've got a young child, go to somewhere where there's a playground, with a cafe, sit there, talk to each other, try and develop a relationship. And the father looked up at me and said, I can't. It's difficult. I said, why not? He said, I've had a significant motorbike accident. I've suffered a closed head injury. I've got a cognitive impairment. I find it so difficult communicating and almost impossible maintaining relationships. The mother broke down instantly and said, you never told me that. And I said, maybe you need to just start having a coffee together and seeing what you can build on. And she immediately broke down and said, I can't afford it. I can't afford to go out and have a cup of coffee. It's beyond my reach. Their attractiveness, their grooming led me to assume that they could communicate, led me to make some assumptions about their capacity to pay to go and have a coffee. And clearly they couldn't. I obviously didn't make a final decision based on their attractiveness, but I made a mistake. I made a mistake about their capacity based on their look. Again, there's the old saying, never judge a book by its cover. It's telling us not to let beauty overtake reason.
Justice Lee, there is someone who's been involved in proceedings where after the proceedings have finished, they discover information that led them to believe that the judge knew a relevant party and deliberately hid this fact. What can be done where confidence is shaken in the integrity of the process after the proceedings are finished?
I wonder if that's a real question.
I'm told it is.
Or a hypothetical.
No?
Well, if the judgment has been delivered, then The question of an apprehension of bias goes to the integrity of the tribunal, goes to the constitution of the court, and if it was able to be successfully argued at a full court level about the fact that there was a reasonable apprehension of bias and the judge had failed to disclose that, then the obvious answer to that is to seek to appeal and run the point. It does raise an interesting question, and that is about personal relationships. And it's one of the tensions, I think, between the way as lawyers we look at these issues and the discipline of looking at objectively from the point of view of somebody who's not a lawyer. For those that have had long experience as both a solicitor and barrister before they're appointed to the court, one is constantly dealing with opponents who are your friends, juniors who are your friends, persons with whom you have long entrenched relationships. It is important when one changes your role to bear in mind that the communication you can have with those people and you would ordinarily have with those people can so easily be misconstrued by others who are perhaps unfamiliar with that degree of familiarity which comes with the relationships one builds as a solicitor, particularly at the bar. And it really is a struggle sometimes talking about unconscious bias or talking about the need that one takes for granted the level of familiarity one has with other people in the legal profession and the people who appear before you, and how that's sometimes perceived by an outsider. There was a very interesting story that I'll tell you briefly in relation to a practice which used to occur commonly in the Supreme Court of New South Wales, and that is the notion that judges, particularly judges in the equity division, would commonly invite counsel in for morning tea during the running of a case. Still happens, presumably, but less commonly than it used to. And I recall one case where I was invited with, in fact, for reasons, I won't give the name of the judge, but he was very keen on having morning tea and was doing it during the course of a long case once a week. Now, that was all very pleasant, although if you're in the middle of cross-examining someone, you're far more interested in concentrating on what your questions are over the morning tea adjournment than having a small chat with a member of the judiciary. But it was clear that one of the parties were very upset and suspicious about this. It was a lovely courtesy that was extended to members of the profession, and on one level it was a very enjoyable experience, and it increased the collegiality between bench and bar. But at least to some litigants, it would be regarded as a somewhat exclusionary. What on earth is going on there? What are they chatting about? Is there some discussion occurring in relation to the case? So it is a struggle. Anyway, I've gone off the topic a bit, but I think it was vaguely relevant.
Sorry, Gabriel, would you like to say something? Of course.
Just to add a small procedural addition to the judge's comments, just in relation to final appellate courts, this question of whether there hasn't been a full disclosure of facts and particularly whether a judge has deliberately hid facts has arisen in other jurisdictions, and the New Zealand Supreme Court had to deal with this question in the Saxony litigation where Justice Wilson and his particular financial and business relationships had not been disclosed properly until after a Supreme Court decision had been delivered, and they found that they had the inherent power to come back to their decision and reassess it, despite the finality of a Supreme Court decision in that jurisdiction. And of course, we see it again, well, we saw it again in the 1998 decision in the House of Lords in the Pinochet litigation, where the information about Lord Hoffman's association with Amnesty International was revealed after the decision, and the House of Lords found it had jurisdiction to return to the decision. So just in that very specific instance of final courts. Thank you.
Thank you. Is Tony McAvoy still on the line?
Hi, still here.
Hello, Tony. We've been asked about perceptions among groups of litigants or the public more generally that judges are biased against particular types of litigants. For example, in the family law jurisdiction, that certain judges are biased against fathers or against victims of family violence. Do you think the apprehended bias test can and should deal with structural or systemic biases at all? And if not, how should we address those issues?
Yes, it's a difficult question, and the difficulties of the manner in which these issues are can be dealt with, I think, was raised by Judge Myers to some extent. I'm aware that in Canada in the 90s there was some study that was undertaken with judicial officers in relation to bias, unconscious bias or implicit bias, and it found that generally those who were aware of their bias could be trained out of it or trained to deal with it, whereas those who were unaware of their bias or didn't believe that they had any bias were very difficult to assist in terms of dealing with that bias. So in terms of any structural biases that might exist against particular groups in society, I'm not sure that the fair-minded observer test, in its present form, can adequately deal with those issues, or B, is the place to address it. The place to address it seems to me to be in judicial education and developing a greater diversity on the bench in some respects that will assist in broadening the public's confidence in the decision making. There are particular issues in relation to the concerns of fathers in the family court jurisdiction, which I'm not sufficiently across to comment on in this sort of forum. Perhaps some other of the panelists might wish to comment on that. I hope I've answered the question sufficiently.
Thank you, Tony. Judge Myers, did you want to add anything?
About father's feeling as though the...
Well, about systemic biases.
I think if we can echo Tony, I think education is an important piece of the puzzle. I'll stand up. I remember being on circuit in a country town and walking down the street past an Aboriginal family, and you might, if you've been to country towns, you may notice that some Aboriginal families are very loud. When they speak extremely loudly, almost at the top of their lungs. And I was with a family consultant walking down the street, and he was talking to me. He said, I know you're Aboriginal, but explain to me this, do they have to be that loud? Do they have to be that loud? And I said to the family consultant, you don't know this, but there is an epidemic of hearing loss in the Indigenous community. The reason they are screaming at each other is because they actually can't hear. And the family consultant I was with was stunned. It was a revelation for him. And he later told me when I visited again, it changed his view about some of the Aboriginal families in the town. And that was, again, only through education.
So, Mr. Merritt, in addition to education and a complaints process, what else should the judiciary be doing to ensure public confidence in what it does?
The judiciary is doing quite a lot, actually, compared to how things were 20 years ago. Good summaries of judgments are now fairly common on major cases. All courts, I think, produce those. Those summaries, when you're presented with a 100-page judgment, are completely invaluable. They make it very difficult for the media to misconstrue the key points. The role of the media, though, is not to be the public relations arm of the judiciary. The judiciary is the public relations arm of the judiciary. The role of the media is to hopefully reflect what's happening in the courts. There'll always be debate hopefully at the margin that some media conduct has not been completely satisfactory. But on my take, those reporters, those journalists who focus on the legal system try very hard to get things right, to provide an accurate reflection of what's going on. And that's the most I think you can hope, the most you can wish for from the media. Might not be a satisfactory outcome, but there you go.
Yes, Justice Stewart.
Thank you. I'd just be interested to know if anyone on the panel has a response to Chris Merritt's point that he made earlier about, which essentially, to put it at its crudest, is that a litigant should be able to sit on knowledge of apprehended bias or knowledge that would be a foundation for apprehended bias, not raise it, wait for the result, lose, and then only raise it. Whether anyone else on the panel has an answer to that.
I think it's dangerous. There's a difference between people not taking points they ought to take through ignorance. There's a long line of cases. Burke's case is the most famous, the Court of Criminal Appeal in New South Wales, where through the ignorance and incompetence of barristers in not taking a point, that may not shut out someone from raising a point on appeal. But if people are competently represented, I think to allow people to, as it were, save up an apprehension of bias point to see whether or not they're happy with the result creates real problems. I'm sure that's not what Chris is suggesting in that very crude way that I've described it. But the fact is, matters which give rise to apprehended bias are waived every day of the week. There are many times that I've come out and the first thing I've said is, well, my self-managed superannuation funds owns shares in company X, or I acted in a similar case against company Y, or I happen to know because my son was on the same football team as a witness, but I have no embarrassment hearing a witness's evidence. There are a range of matters which might reasonably give rise to an apprehension of bias which are waived every day of the week. And so the mere notion of waiver in and of itself can't be a problem, it seems to me. Having said that, I think the point Chris makes is a good one in the sense that if one looked at the example you used where the barrister was harried and had faced this barrage, this constant barrage of personal criticism, it perhaps is not unexpected that he wouldn't have had his wits about him, even though he was a silk, to be able to make the application. That was an extraordinary set of circumstances. There's got to be some ability at the margins to allow apprehension of bias cases in those unusual circumstances. But as a general notion, the fact that one can't waive circumstances which might give rise to an apprehension of bias, I see real danger signs in.
Can I just... Sorry. Thank you. And just to, I think, perhaps further elaborate on this idea of perhaps special circumstances rather than the general rule. And I think it was something that Chris was alluding to in his comments. So H.P. Lee and Enid Campbell in their book talk about the potential that there may be some such egregious cases of bias where parties cannot waive, and that there's a constitutional requirement of fairness that would mean that parties can't waive. So that's I think, an additional complicating dimension to this. And I just wanted to raise it now because I think it comes off Justice Lee's comments and because we haven't talked about it during this panel, which is the position of the legal professional appearing before the judge and the calculations that a lawyer appearing before a judge must make as to whether or not they're going to bring an application for a judge to disqualify. And certainly, anecdotally, what we've heard is that legal practitioners are very wary of bringing this application. If they're not successful, that judge will then sit in that case and make a decision about their client with the potential unconscious bias or maybe even conscious bias against the person who dares question their impartiality. Of course, the ideal of impartiality so important for the good judge. So I think that's another challenge of the current procedure for disqualification. Thank you.
Yes, sir.
My name's Michael Wilmot. I'm Senior Counsel practicing at the New South Wales Bar. A rather fundamental issue, or rather less high-minded than some of the matters that the panel have addressed, and that is the question of costs. If a hearing is aborted because of a finding, or the judge decides to excuse himself because of obvious bias, or there is a decree by an order by an appellate court for a new trial, there's not just the emotional costs for the parties, but the costs, the legal costs, the practitioners, the cost of getting witnesses, having another trial. How can that be addressed when it is something which is not the fault of the parties? Is it possible that a judge should be ordered to pay the costs? That might be unthinkable for members of the bench. Justice Lee might take the view that that's just not possible. But it's something which is also a matter that when dealing with the point about whether counsel decides to make the application, having that in mind. Cost is a real issue, particularly if you've had a long trial.
Well, I take perhaps what might not be thought as a surprising position, that cost orders should not be made against judges. But leaving aside that, you're quite right. It's a point I tried to touch upon in my brief presentation earlier, because there is often this tension between cost and practicality and the notion of having a tribunal which is free of any taint of apprehended bias. They're the sort of considerations, these cost considerations, as you would appreciate, Michael, which have informed this notion that judges should be fairly prudent when it comes to making a determination and perhaps err on the side of disqualifying themselves. But that can lead to other costs and delays. If a judge does disqualify himself or herself, then one has to find another judge. Disrupts other people's lists. Of course, the costs of on an individual basis, leaving aside suitors' funds, certificates, and that sort of thing, which are far from satisfactory regime, there's very little that can be done about it, except the judge who fears that there may be an issue to try to determine in a way which does not prevent, which causes the least potential wasted costs. One of the reasons I heard that Web and Get Swift determination when I did was because if I went on and then heard the class action, there may be a question, depending upon what the full court does, of saying that I had access to extraneous information in respect to the regulatory proceeding. If that case went for 8 or 9 weeks, that would be a scandalous waste of public resources apart from the private resources. So you've just got to hope people do it in the best way to prevent unnecessary costs. But I fear, at least to some extent, it may be an insuperable problem.
Well, I think we should bring this seminar to a close.
In thanking tonight's speakers, there are 4 or so matters that I wish to touch on briefly. The first is this: that I think Tony McAvoy spoke in passing at least about codification, and I suppose one thing that needs to be borne in mind is to avoid if there is to be any sort of codification, statutory codification, is to avoid any sort of fracture with judicial systems or judges who are outside the terms of reference. I think it would be unattractive for there to be some statutory mechanism where state judges, state judicial officers were under a different regime, and how would that work with state courts exercising federal jurisdiction? So that's something to keep an eye on. Second thing I want to mention is procedural fairness is about process and not result. But contrary to common perception, that a judge decides against you does not mean that he or she is biased in any presently relevant sense. So I think that the trust that was touched on, and no doubt important for the people who appear in courts to trust the system, I think that is related to knowledge about what the rule is meant to be about, what the principles of procedural fairness in this context are meant to be about. Justice Mason in 1986 put it in this way, which is probably unpalatable to some people, but it shows what the principles and rules are meant to be about. His Honour said there may be many situations in which previous decisions on issues of fact and law may generate an expectation that the judge is likely to decide issues in a particular case adversely to one of the parties, but this does not of itself mean either that the judge will approach the issues in that case otherwise than with an impartial and unprejudiced mind in the relevant sense, or that the judge's previous decisions provide an acceptable basis for inferring a reasonable apprehension that the judge will approach the issues in that way. So that's something to bear in mind when one is trying to identify the bedrock of the principle. What people in general language talk about as bias is not what the rule is about. Related to that, I want to draw your attention to what the Court of Appeal judge in England, Stephen Sedley, said. He wrote an article, Recusal, apologies to Justice Lee, when should a judge not be a judge? And I think this is an important point. He said, the risk of bias is not limited to favouritism. There is an equal and opposite risk that a judge, in endeavouring not to show favour, will bend over backwards and lose his balance, his or her balance that way. The only safe route is the exit. I think that relates as well to the point that Judge Myers was making about unconscious bias, an unconscious bias of endeavouring not to show favour. Next, I wanted to draw to your attention what His Honour Keith Mason said in a paper he wrote in 2014. that judges should not only know themselves and their own biases to the extent possible, but they should also suspend judgment for as long as possible. And in my view, apprehended bias by reason of prejudgment is really the mind which is closed too early. But also bear in mind the trenchant observation of Chief Justice Spiegelman in the McGovern and Ku-ring-gai Council case in 2008. No doubt in most contexts, an open mind must be regarded as a good thing. However, a mind that never shuts will generally be a public nuisance. So there's a world of difference between a judge apparently expressing concluded views at a first directions hearing, on the one hand, and a judge using similar language in the course of testing counsel's submissions on the final day of a lengthy trial. But even the second of those examples, the necessity of it really might be lost on the real lay observer as opposed to the hypothetical lay observer. The third point I wanted to touch on was whether there is, and this goes to what Professor Appleby was speaking about, whether there is efficient and economical procedural alternative to applications to disqualify not being made to the judge in question and being determined by that judge. Justice Lee made this point, or I'll put some words into his mouth. Many applications for disqualification are misconceived. Some are tactical, some are both. There is, of course, a difficult issue as to whether an unsuccessful application should be the subject of an appeal then and there, so that there's no risk of the trial miscarrying. But a judge who has rejected an application for disqualification may nevertheless find for that party in the trial itself. The last point I wanted to make, and Justice Derrington referred to the appointment process as being part of the reference. The executive really must take great care in appointing Chapter 3 trial judges. The judge is likely to be there for a long time, including in what I'm saying here, the point Chris Merritt made about judges' health and welfare. Necessarily, to preserve the independence from the executive, it's very difficult to remove a Chapter 3 judge. But as far as possible, the executive should make an assessment not only of the prospective judge's legal skills, but also their temperament, whether they're good at listening, whether they're patient, whether they're self-important, are they what I'd like to refer to as are they a person with issues? So you can have a very good legal, a lawyer with very good legal skills, but the question is, do they have good judgment? You can have principles about apprehended bias, rules about apprehended bias, but one of the safeguards of ensuring absence of bias and apprehended bias is to make sure that you choose the right people to be on the Chapter 3 courts in the first place. That's all I wanted to add. Once again, I thank tonight's speakers for their generosity in taking time from their busy professional lives to speak to us this evening. So please join with me in thanking them.
So that brings us all to the end, and we look forward to engaging with you when our consultation paper comes out. Thank you all.